wish you could switch the screen.
What do you mean switch it?
Because it's not mirror image.
This is Beach Talk Radio.
Good morning, Mr. and Mrs. America, and all ships at sea. This is your captain speaking, Mean Gene. Mean Gene. The following will be a test of the ship's whistle, the sonar alarm, the cable alarm, and the atomic attack alarm.
Live from Peach Time Out in the heart of Times Square. You're listening to Beach Talk Radio with Kim and Ed Ryan.
And a good evening, everybody. Welcome to a special Thursday edition of Beach Talk Radio. We are broadcasting live from our home studio, and we'll be back on Fort Myers Beach Saturday morning at 9 o'clock with our guests. Our guests will include a couple of folks from the Bay Oaks Committee, and Chris O'Neill is coming back to talk about the 4th of July. So that's all coming up. And as you know, on the beach, there are many issues going on, but the one that we're going to talk about today involves the not specifics of the dune walkover, but things that revolve around the dune walkover, such as the Fluidra process and Bert Harris lawsuits. And here taking some of our very important time to spend with us is local attorney Beverly Grady. And Beverly, first, thanks so much for coming on. We appreciate your time.
Good to be here. Good to see you.
Now, at first, can you kind of fill in our audience a little bit about your background, the firm you work for, and the kind of work that you do?
Sure. I'm an attorney with the firm of Retzel and Andrus, which has offices Naples, Fort Myers, as well as Chicago and Ohio. And my area has always related to city, county, and local government. In fact, I'm certified by the Florida Bar in city, county, and local government. So I've worked for the government as an assistant county attorney in cities, and I represent the private sector also with regard to state and local government decisions and applications.
So go ahead. So at first, can you explain what the Fluidra process is?
Sure. So that's an acronym, and it stands for Florida Land Use and Environmental Dispute Resolution Act, of Fludra. Before there was Fludra, if a property owner received a decision, there was a denial, you went to litigation. So in the Fludra, focus on the words dispute resolution. It includes owners denied permits in rezoning, any kind of permit, state agency, or can be an enforcement action that they want to contest. And by that owner filing a petition, they have the opportunity to go through a process to try to have mediation, in effect, to see if they can have a different solution rather than litigation.
Now, does this have to occur before they go to a Bert Harris? Is it part of the Bert Harris? How does that work?
No, it's not part of the Bert Harris process, although the Bert Harris and the Fludra were adopted under Chapter 70 of the Florida statutes, both in 1995. You can have the Fludra process by itself, and if it results in a settlement, that completes it. If it does not result in a settlement, you then can go to litigation. The same in Bert Harris, totally separate. There's a process for filing a claim and determining what you can do with your property. And that actually, the second part of the Bert Harris is litigation. Why do property owners choose to file a Fludra? One of the benefits is if they don't want to go to litigation, when they file that petition for a Fludra, it stops the statute of limitations for litigation. They can proceed through that whole mediation process, and then if it fails, the clock starts again on litigation for the statute of limitations. And if you want to talk about the process, I can kind of just briefly review what that process is.
Sure, go ahead. That'd be great.
Okay, so when the property owner files a petition for a Fludra, the government and the property owner work together and they choose a special magistrate. And the special magistrate will hold a proceeding. Part of that process is notice is given to the adjacent property owners of the property and anyone who participated in the proceeding, say before city council or the local planning agency. So they're notified this Fludra petition has been filed. They have 21 days to return notice that they want to be a participant, that they want to have notice of the proceeding. The government and the property owner set a date for a special magistrate proceeding. Those participants who filed will receive notice of that proceeding. And when you go to that proceeding, the special magistrate holds two separate parts. The first part of a FLUDRA is your mediation. There's an attempt for the government and the property owner to explore, are there changes, alterations that can be made, lowering intensity, shifting of site plans. It's all on the table to see if the government and the property owner can come together. Now, since it's a government, whoever attends on behalf can't bind the council. It would have to, any settlement that's proposed would have to go back to the council for a vote. Mediation doesn't work. There's no agreement that can be reached between the government representatives and the property owner. So now the special magistrate moves into part two, and it's a hearing. And so at that, the petitioner would present their case and testimony, any information that the special magistrate needs to fully understand the case, the issues, and the position of the petitioner. And then the local government does the same. They present fully their position and their information on why this decision was issued in a case like by the council. And then the participants, if they get to speak, because perhaps alterations and modifications have been presented, and the participants then do get to speak to either whatever's a settlement or whether it's gone to the full-blown hearing, they get an opportunity. The special magistrate may put time limits on that, but at the end, being fully informed, the special magistrate closes the proceeding and has 14 days to issue a recommendation to, in this case, the council. Both if it's mediation or if it's a recommendation after a hearing, the council has full authority to reject what's been submitted, accept what's been submitted, change what's been submitted. And with that decision, then, if they reject and the original decision basically stands, then the clock starts running on the litigation, and the property owner can decide if they want to proceed to litigate.
So, Beverly, if let's say a government agency has rejected whatever it's a special exception or whatever it is on the homeowner, and the homeowner goes to mediation with the attorney and whoever represents them, and then the mediator makes a recommendation to the city council, and it just so happens that the city council has different members, can they actually take a vote to approve the special exception right there and say we want this to end, we don't want to spend any more money, we think that there's a possibility that we might run into the millions of dollars and we don't want to have taxpayer dollars go to that? Can they just say, okay, here's your special exception, or is there a long process in that?
So what I've seen local governments do is to make sure procedurally whatever decision they make stands. I've seen them go ahead and do the appropriate advertising, just like they did for the original special exception, and send the notice out to the surrounding owners within the footage that needs to be sent. So yes, when that recommendation of the special magistrate or the mediated settlement is presented to council, they have the ability to that day take a final action. That final action could include approval of that permit at that point. They will be taking the testimony and the input from the public. They will hear from the applicant, they will hear from the staff, and they'll be considering the recommendation of the special magistrate. If as long as they do the proper advertising, that's the experience that I've seen from local governments. The FLUDRA statute itself doesn't spell out detailed procedure how to handle the special magistrate's decision. It just says you can accept it, change it, reject it. But what I have seen local governments do is make sure they do the proper advertising like they would do for the original decision to give themselves full authority to make a decision.
What is your experience with Bert Harris lawsuits in terms of do they lean more toward the property owner winning? Do they lean more toward the government winning, or is it all over the board?
I think what I would say is if so many of the Bert Harris cases really delve into the process. That is, there is a strict procedure that the property owner has to meet. You'll find a number of cases that the property owner may have filed too late. Property owner didn't file an appraisal that's acceptable. There are just a lot of procedural steps. They will find, the property owner has to establish that they have either a vested use or an existing use. And by the way, that existing use is a different definition than all of us think it means, because it can include a future use in the statute. So that's a little confusing, that an existing use, by definition in the statute, can include a future use that would have been reasonable and non-speculative. So the courts may find that the property owner didn't establish a vested use, didn't establish an existing use. And let's just talk about process. The Bert Harris claim at the beginning includes the ability to have settlement agreements, change the application. Government has to write a letter, to them telling what their allowable uses are. But if they don't come to an agreement within 150 days of the Bert Harris notice of claim, that property owner can file suit. And if they file suit, and if the property owner establishes the criteria, they have an existing use, that they were denied, and because the government placed an inordinate burden on their property, and it was for the benefit of the public. If that happens, that finishes piece one, and that can be appealed by the governing body to the next court. And if the government loses, then you go to part two. What's the compensation? Because the Bert Harris claim, when it gets into litigation, is what is the value of the property without the restriction? What is the value of the restriction that the government placed on them by denying them or putting some regulation on them? And then the difference is what the property owner is claiming. That's decided by a jury. Also in Bert Harris, when you get to that position, the prevailing party is able to get attorney's fees and costs. So that everyone is taking account of that. That's huge if you have to pay for the attorney's fees and costs for the other side. So a number of Bert Harris cases actually do result in some kind of settlement. May not be what the property owner originally asked for, but there have been a number that have been that arrived to some type of settlement.
And that settlement, is that something that the two parties can kind of figure out or discuss or agree upon, or is that something that the jury decides?
Okay, so definitely when the property owner files a notice of claim, they cannot file the lawsuit for 150 days. So during that 150 days, the statute contemplates that the government and the property owner will at least be exchanging information, seeing if there's a settlement agreement. And let's just say that doesn't happen, so the property owner files suit. They still can come to a settlement agreement just like you do in any lawsuit. The court won't order that. The court won't have any part of that negotiation. But when there is a settlement agreement, it can happen even after the lawsuit is filed. If they don't settle, then it would be purely, did the government and the property owner prove that the government placed an inordinate burden on that property for the benefit of the public and meet all those statutory criteria? In that case, then the next determination is what is the level of compensation to make that property owner whole. I mean, the Bert Harris claim those started in the late 80s and in the 1990s, when it was clear that actual taking places where you really have to show that almost all value of the property was taken were required almost decades in litigation at times, and very confusing determinations. So a number of states, including Florida, adopted a private property rights protection act, and that was basis. And it does offer a new cause of action where the government places an inordinate burden on a particular property because it wants to attain a benefit for the public.
So back to the original question of have you seen it? Which way have you seen it sway more of? Is it more in favor when it gets to the level of reaching the judge? Is it more in favor of the homeowner, or is it more in favor of the government, or is it an even split?
I don't have that. I don't have that number. I would say more is actual settlement agreements, something that's actually negotiated. For being in place in 25 years, there are not a lot of cases that actually have proceeded all the way to the end. So that, I think, is, and I don't have that number, but many of them end up on procedure or end up with some type of settlement agreement. And on the procedure, that's where the property owner has lost, because there's certain elements you must have established, and there's a number of cases where the property owner has failed to do that.
And when that happens, is that, I mean, the property owner has representation, correct? So legal representation through this whole process. So then that has fallen on their shoulders to kind of make sure that things are in order, not the property owner isn't. I mean,
well, again, I mean, the property owner has to show they have a vested use, which means something that they had, that they thought the government actions that they were entitled to, and they relied on good faith, and they've expended money. So that's kind of vesting. Or they have to show an existing use, which doesn't mean it can be present activity, but it also can be a future use that's non-speculative, that's foreseeable. Now, I just said words that a lot of people could interpret differently, which is why you have the litigation. What is a use that's non-speculative, foreseeable, and therefore becomes an existing use that is recognized by the courts to that property? So yes, there's litigation on that, but I mean, it is not just black and white. It's not just clear cut that one can say. You would say, here are my arguments for, and the government's going to say, here are my arguments against. That's why you have a judge.
Go ahead.
So if the homeowner wants to build something that's totally on their property, why does the government get any say in what they're doing? I mean, unless it's a big giant second pink house or something like that, or it's something they did have and then something that was taken away by nature that they're trying to get back to keep the value of their homes up. Why is the government able to inflict their rules on the homeowner like that?
Well, I would say that if you in Florida, permitting and land use are issues, daily issues. If you talk about zoning, that is actually what you're saying is, why do we have zoning? Why do we have, why do we have zoning, and how can that be sustained? So there are comprehensive rules in every single city and county with regard to what you can or cannot do with your property. So you have permitted uses in your zoning. It's a matter of right. A special exception, there's a list of criteria that you have to prove at a quasi-judicial hearing. And different councils or elected bodies may look at facts and interpret them differently, but there are rules on the books, and we deal with them all the time, and they deal with what you can or cannot do with your property.
How expensive can a lawsuit like this become if it goes on and into the Bert Harris phase?
Well, you need an appraisal. I mean, it's two-tiered. One, you're going to be establishing in the first trial whether you met the elements of the Bert Harris. If the property owner fails, case is over. If the property owner prevails, now you'll be putting on experts with regard to the value of the property and sustaining what the damages are. So, I mean, you're probably looking six figures.
Same thing for the government.
Yeah, could be. Mm-hmm.
So once they agree that they've met all the procedural qualifications for the Burt Harris, then it goes straight to, and they've won, it goes straight to deciding how much.
Right. There's a phase 2 held in court. The judge is presiding, but there is a jury to determine valuation, the amount of damages.
And then does the jury have to, like, how many people are on that jury, and does it have to be a unanimous decision? Like, how do they figure that out?
Well, I would say, really in some ways it's done all the time. Eminent domain. When the government needs to take property, there's an initial hearing where the government shows justification that it's needed for a public purpose. Phase 1, usually a quick take. Phase 2 is if the government and the property owner can't agree on the value of what was taken, you go to a jury trial. And in eminent domain, it's a 12-member jury. And so they determine valuation, and it is listening to experts on both sides. Some valuations include engineers, certainly appraisers. So depending on what you're valuing, you certainly will have an appraiser from both sides testifying as to the difference in the valuation of the property due to the inordinate burden.
So Beverly, what is a quiet title and a quick claim deed?
Okay, so a quick claim deed, it really is saying, and it's really fairly common in researching title. You may find some claims or some deeds in the past that maybe weren't totally correct, or they have a foundation that could cause a problem. And yet the intent there was no question about what the intent was. So you will have people, when they sign a quick claim deed, they're saying, whatever interest I have, I may have nothing, but whatever it is, I'm conveying that to you. And it just it can clear up some problems. So the person who's signing it may have actual property rights, and they're conveying them. The person may have nothing. They are not promising you anything. They're just saying, whatever I have as to this piece of property, I'm conveying whatever that is to you. Now, separately, you can have properties that have gray areas. There's an easement on it, but we don't know, was never defined. Well, where is it located? And are there any restrictions on it? Or maybe it doesn't even affect this property. So you'll see people will sometimes file a quiet title action, and the purpose is just to clear up the title. So everybody knows what rights you have or what rights may be over your property. So it's a way of where you can't come to an agreement with some other person that has a claim. The judge will decide and issue a final judgment, clear up those property rights.
Now, when you're talking about property and at the coastal areas where the coast changes, now a deed, just so I'm correct, when you get a deed, the original deed stays the same regardless of who buys the house. Is that correct?
Yeah.
So then if your property includes some area that changes because of nature, and say, is there a way that, if the sand accretes, you get more property, or if it erodes, you lose more property? How does that work with the mean high tide line?
Okay, so you have a deed to a piece of real estate, and then you also have common law. So if you actually have a deed and you own to mean high water, and we have a dynamic shoreline on all of our barrier islands. So let's say there's accretion, then yes, under common law, you have ownership to mean high water. As that accretes, you're still have the ownership to mean high water. An example is where you have severe erosion and you're actually losing property. And of course, we've seen our beach nourishment projects, and we have the DEP and even the federal government providing public funding to help finance some of those nourishment projects. So in that case, the statute has provided where the DEP will come in and establish an erosion control line, and then by using public funding as well as private funding, replenish the sand. And now the owner of the land on the water side of the erosion control line is the public. even if it used to be part of a deed, because in order to have that project, and we're going to use public monies, then the way that works is land on the waterward side is subject to public use. The owner keeps the land on the landward side of the erosion control line.
So let's say the deed gives you the house at first, or you have the property up until the seawall, and then there's water coming up to the seawall, and then something happens 10 years later, and then there's another 150 feet or whatever the number is out to the water, and the high tide line goes out there, and so it changes, right? So it changes to whatever the state changed the high tide line to, right? So far.
Well, and that's where you want a really good surveyor, because the determination of mean high water is it doesn't change every year, doesn't change in 10 years.
Right.
I think it's a 19-year average. So you want a surveyor who understands that, and that can, help and show you where the ownership line is.
But just for argument's sake, let's say it's out 150 and everybody agrees that it's where it used to be by the seawall. Now it's 150 feet out, and there's a critical wildlife area right in the middle of it between the homes and the mean high tide line. Who owns that?
I mean, I wouldn't even begin to address that without sitting down with a surveyor. I mean, because there is no yes or no answer to the facts that you just gave me.
Okay.
All right. You have to look at the original deed, and if it's part of a plat, you have to look at the plat.
All right.
And then you have to talk to the surveyor and look at the surveyor as to where the mean high water line is. And you want the title policy and the title work that's been done on all the property you just talked about.
Okay.
Can you talk a little bit about, and I don't want to say it incorrectly, riparian rights and literal rights, as far as property that goes up against water, and what the differences of those two are?
Well, really, that's a good question. The courts recognize, and you'll even see it in one of the main cases, the rights that go with it are very much the same. One applies to lakes and the other applies to like the Gulf of Mexico. But the rights are basically the same. The right to access, the right to wharf out, the right to a view. And so you do have some rights when you buy land on water that are riparian rights, and there's significant case law on riparian rights. But those are basically the right to wharf out, the right to have access to the water.
So you have any other questions about the Bert Harris stuff? Because I wanted to, while we had you on the line, I hope you don't mind, because you're a government expert. There's a huge issue going on right now, and I wanted to get your thoughts on what you think. With the government's enacting the mandatory mask thing, do you believe that's legal?
All right, so there are powers under Florida statutes, emergency powers, and they provide power to the governor. They also provide power to local governments. So if under those powers, as long as it's properly documented in the resolutions that they adopt or the ordinances that they adopt, and they're doing it for public safety, health, and welfare, if they are able to document that restriction with that need, I mean, I think that's where anyone who is looking to attack it is going to look at how did they make that connection under their emergency powers to adopt some particular restrictions.
Do you think there are going to be lawsuits all over wherever they're trying to do this? People talk about that all the time, but they do throw that around no matter what's going on. Do you think that we're going to see a slew of those because of the masks being mandated?
Well, what I always tell people is you can always be sued.
Right.
The question is, are you going to win? And along with that, just being sued is expensive. It's time consuming and expensive, which is why we have like the Fluger process to see if that can be avoided. But no, I really can't. I mean,
right.
There may be lawsuits, but I couldn't possibly tell you without, reviewing the restriction and how they supported that, whether they'll be upheld or not.
Just one more question on that. It's a kind of a Robert's Rules thing, and I don't really understand it all that much, but when you go to make a motion to whether it's the mask thing or whatever, and then you change it in mid motion to a emergency declaration, do you need to take public comment?
In your example, you're saying public comment was taken,
Was
but
not taken.
at all?
No, zero on that specific item during that specific motion.
Unless I really
saw what happened.
saw what happened,
Yeah.
Didn't give you an answer that would be worth anything.
Okay.
I have one sort of obtuse question. So,
like mine warrants.
when you're looking at sales of homes and it says the sales disqualified as a result of examination of the deed, what does that mean? Because the sale still went through. What does that mean?
Okay. So remember, you're looking at the Lee County Property Appraiser website.
Yes, I am.
The Lee County Property Appraiser is concerned about one thing. What is the value of your property? Because he's to assess it at 100% fair market value. So if he gets a deed where a husband and wife own a piece of property and then they convey it into the husband and wife's trust, the value on that deed probably says like, $10 or some other nominal amount. So he's going to say, that is not the fair market value of that property. Therefore, I've examined it and I'm not going to consider it for purposes of valuation by the property appraiser.
Okay.
It was valid. The property got conveyed to the trust, but it doesn't change the value of what he's already established as fair market value.
Okay. So that's really a money thing. It's not there was something
wrong
with the deed. Okay. All right.
Any other questions for Beverly?
I have lots, but no, we'll let her know.
Well, Beverly, thank you so much for your time. We really appreciate it. And we hope you have a safe holiday weekend. And what else?
Why don't you give out your contact information?
If anybody needs to sue somebody or just wants to chat with you or anything like that, or.
All right. Well, yeah, please contact me at Rutzel and Andrus, and it's 239-338-4207. And I do wish everyone a very safe and happy 4th of July.
Thanks, Beverly. Have a great weekend.
So much.
Thank you. You too. Bye-bye.
And before we go, dear, I just want to address one comment there from Paige. I just want to clarify. She said that I was unfair that there was public comment taken. There was public comment taken at the beginning of yesterday's meeting. There was no agenda on mask. Nobody knew that the mask, I guess they could have assumed that the mask was going to come up during the meeting yesterday. The mask, there was no agenda that said, we're going to talk about parking. We're going to talk about buses coming to town. We're going to talk about closing the beach and masks. There was nothing like that. The motion for the mask, as you know, came up at the end of the meeting. And then it was changed. Roger wanted it changed to a declaration of emergency declaration. And that's where they're skirting the public comment. That's where they are going to be fine with not asking for public comment. I guess I would always prefer that there were more public comment than less public comment. And as you can see in the Cape Coral meeting today, there's a ton of public comment about the masks. And that's what I wanted to see on Fort Myers Beach. Give the people a chance to voice their opinion about the mask. The mask wasn't as important to get done right away as closing the beach was, because the 4th of July weekend. The mask could have waited 1 day or 2 days. It's not like these masks weren't talked about for months. They're good, they're not good, they're good, wear them. Everyone's got to wear them. So 1 more day or 2 more days to allow for real public comment, not guessing public comment at the beginning. I bet you would have had a full house there.
Well, I will also say that they did say that they received a lot of emails and that some of the emails did discuss people's opinion on the mask. And at the beginning of the meeting, Ray did say, we're going to talk about this and we might talk about the masks. And
I don't know what she's talking about, the general description. was what they were provided. So what you're doing here is you're just trying to get people to guess so they know, instead of being more open with the public and telling them exactly what you're going to talk about. That's what you're saying. They could have put it on the agenda page, because the agenda, the blank agenda, was on the website. Why can't you list the items on the agenda? Well, you can. If you want to give the public more information, you can.
Well, I agree that it was weird that only 2 people showed up to give public comment in general.
Right.
I mean,
it's 1 o'clock in the afternoon.
Well, I was at the Sanibel meeting. There wasn't a ton of people, but there was more than 2 there. And
I'm not saying more people would have showed up.
Right. Well, they had a draft.
It was clearly about COVID. I'll give you that. It was clearly about COVID. That could mean anything. Mean anything. So it could mean 1,000 things. But anyway, we're getting stuck on that. I just wanted to clarify that. But if you're not busy tonight, the Cape Coral meeting will probably go on for hours, and there's some interesting feedback going on there.
There's some interesting presentations.
Yeah. And what happened too was that one of the council members read Jason Maughan's letter, and Jason is obviously against Jason Maughan is against wearing the mask. He voted no. He was the only one voted no. My guess is Kevin would have voted no.
Well,
what was the letter about at the beginning? Was it about closing, or was it about the mask?
Yeah, he would
have voted no.
He would have voted no.
No on the mask. So anyway, in Cape Coral, they read Jason Maughan's letter, and the crowd erupted in claps and applause, because they don't want to be told what to do about the mask. So anyway.
Well, he would have voted no about the parking. I don't remember about
if it was the mask.
About the mask.
So we will have masks on during the show on Saturday. So we hope to see you guys down there with your masks, and follow all the rules to the new ordinance, which is, I think it's in place now, or 1201 tonight, or 1201 today. So our guests on Saturday will be 2 members of the Bay Oaks Committee, so that we can talk about what the expansion plans are there, and Chris O'Neill, a great American, to talk about the 4th of July. So have a safe one, everybody, and thanks for tuning in for our special Thursday night show, and bye-bye.